Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today's the day I earned that subscription. For today's story, we turn our attention to Gina Carano versus Walt Disney, as it relates to discrimination in relation to the firing of her from the Star Wars series. Gina Carano, as I'm sure some of you are aware, was participating in she was participating in The Mandalorian, part of the Star Wars series, and then she was fired from the Star Wars series as part of Disney's decisions, which they say are due to, issues of incompatibility, and she says are due to issues of discrimination. So we're going to read this lawsuit and see what it has to do with that. So let's go ahead and get started with this. We turn our attention. We are in federal court, United States District Court for the Central District of California. Gina Carano versus Walt Disney Company, Lucasfilms, and Huckleberry Industries. Let's read this complaint and see what we've got in sort of all that going on. Gina Carano files the following lawsuit. Introduction. A short time ago in a galaxy not so far away. Okay, that's a little tired for my taste, but let's press on. Defendant made it clear that only one orthodoxy in thought, speech, or action was acceptable in their empire, and those who dared to question or failed to fully comply would not be tolerated. I mean, Disney is entitled to their own views as far as it goes, but let's see what we got. And so it was with Carano, as two highly acclaimed seasons on The Mandalorian, as Rebel Ranger Cara Dune. Carano was terminated from her role swiftly as her character's peaceful planet on Alderaan had been destroyed by the Death Star in an earlier Star Wars film. Okay, this is a little trite, but okay. And all this because she dared to voice her own opinions on social media platforms and elsewhere, and stood up to the online bully mob who demanded her compliance with their extreme progressive ideology. Well, what we can say is that Disney World and Walt Disney are, of course, entitled to its own viewpoints, and so is Gina. And so we are going to have to find a specific hook in state law relating to this, and we'll see how our hook goes. Defendant's wrath over the employee's social media posts also differs depending on sex. Even though the force is female, which is a quote I haven't heard before, but okay, defendants chose to target a woman while looking the other way when it came to man. All right, so we want to argue discrimination on the basis of sex, rather than discrimination on the basis of viewpoint. All right. While Carano was filed, defendants took no action against male workers who took equally or more vigorous and controversial positions. Okay. I mean, this gets a little bit tricky as it relates to things because, of course, you are not necessarily required to be perfectly consistent in your thinking as a general proposition. And you're required to pick your favorites, as it were. So ideological consistency is not a requirement. But maybe if we can prove it was specifically on the basis of sex rather than ideology, maybe. But that's going to be tough, as we're dealing with speech. But we'll try. Kathleen Kennedy actually said that before a new Star Wars film. Noted. Kathleen Kennedy is an idiot, so no wonder I didn't note that she had said that, but fine. Also, I'm not sure it really legally matters, but, noted. But the rule of law still reigns over the defendant's empire, and Carano has returned to demand that they be held accountable for their bullying, which is legal, discriminatory, which might not be, and retaliation actions, which might not be. Actions that inflicted not only substantial emotional harm, but millions of dollars. So we're going to go bullying for emotional distress. Is that where we're going to try to go? All right, let's give that a shot. Jurisdiction is because Carano's claims are between persons and entities of different states and exceed $75,000. Fine. Venue is proper because a substantial part of the claims exist here and were employed by the district. That makes sense. We're dealing with filming. California seems like the most logical choice. Carano brings this action under California state law, which of course it has to be, because I don't really think there's any federal law in point unless we're going to try to squeeze this into a civil rights Act case, which seems difficult, but state-specific law seems much more promising. Carano has requested and received notice of right to sue from the California Civil Rights Department and otherwise exhaustive administrative remedies. Fine. That's going to turn on California-specific law, but she said she's done with all those things, so that's fine. This is a civil action arising from defendant's wrongful termination of employment in retaliation for Carano's lawful exercise of a right to speech and express her views. I'm not sure that that's illegal. If it were the government, yes, because the government can't discriminate against you for your viewpoint, generally speaking, although it gets tricky as we separate whether or not you're speaking in your personal capacity versus your individual capacity. But given the premise that you're speaking in your individual capacity and you work for the government, then yeah, they can't do that. But a private entity can. They can retaliate against you for your viewpoint. That's not illegal. Specifically, defendants under the regime of the former Disney CEO fired Carano because of her posts on various social media platforms, which isn't illegal. Carano composed and published the post while she was off duty and away from the workplace, which is irrelevant because it's not the government. In her post, Carano expressed her personal political views, opinions, and beliefs. In retaliation for Carano's exercise of her speech rights, defendants terminate Carano's employment and took away other retaliatory actions to limit and deny her future employment opportunities, including but not limiting to malicious false statements with intention of damaging her reputation. So we're going to try tortious interference with prospective economic advantage. That gets really tricky unless you can point to specific contracts or specific deals. That gets tricky to do in general. So if you can show their interference with specific relationships, then yes. But as a general proposition, that's hard. Further, defendant treated Carano differently than her similarly situated male co-workers, who likewise expressed their personal political views on social media, but abhorrent information belief were not counseled or disciplined. All right. So again, as to a private entity, they're not necessarily required to be consistent when it comes to a First Amendment perspective. Now, maybe there's some state-specific law. We haven't discussed any state-specific law yet, but the nature of the complaint so far doesn't seem particularly optimistic, just on general law principles. So if we're going to go to some California-specific law, our analysis may very well change. But on general law principles, this is going to be really, really tricky to prove. Disney has, as a general proposition, has a right to have its viewpoint, and they have a right to discriminate against other people based on their viewpoint, because that's not a protected characteristic with respect to federal law or most state laws, although maybe California is different, and there's some California state-specific stuff. We'll get there if we get there. But Disney, it is not illegal, generally speaking, to discriminate against someone because of their viewpoint. And you don't even necessarily have to be consistent about it. And to try to prove that it's based specifically on sex as opposed to nuances in the viewpoint would be tough. So far not great, but maybe it gets better. Carano is a resident of Montana. Great. Walt Disney lives in California. Great. Lucasfilm also lives in California. Fine. Defendant Huckleberry Industry lives in California. Great. So we got Montana versus California. We've got diversity jurisdiction. That sounds great. So we can be in federal court. Great. All right, let's learn a little bit more. Sermon says, I think California has political speech as one of their protected things. Very well may be. And I'm sure they're going to inform us about the law. Now, I was talking to Nate, the lawyer, about this a little bit, just a little bit, because I was a little confused on something. And sometimes when I'm confused, I like to call other lawyers too. So I asked Nate, the lawyer, because my knowledge of California law was California has long protected discrimination on the basis of political affiliation. However, my knowledge of California law was that California courts have interpreted that historically very narrowly. So it only applied to like official party affiliations and maybe attendance at official party events, but did not apply historically at broader political advocacy. So they interpreted it very narrowly. However, Nate, the lawyer, correctly informed me, I assume, because I have no reason to doubt him, that as a response to the Black Lives Matter movement, that California may have updated its case law. So my knowledge on California case law is a little bit old, because if you asked me this question 5 years ago, I'd be like, no, not going to happen. But of course, it's well possible California has changed its case law since. So we're going to learn the law together, which I'm excited about. I like to learn law. You like to learn law. And one of the things, of course, a good lawyer has to do is be a teacher. They have to teach the court, because the court might also not know, especially because it's a federal court. And even if it were a state court, to be quite honest, because no state judge can know everything. And a federal judge definitely doesn't necessarily know the intricacies of every particular state law, because they deal with a lot of federal law issues, and that's a lot to keep in your head too. So a good lawyer is a teacher. It's right in the name, Juris Doctor, a teacher of law. So one of the good things that a lawyer needs to do is teach. They need to teach the court. They need to teach the jury. They need to teach so that we can all learn. So, hey, counselor, teach me. I'm excited. And then to the degree to which they teach me, I can teach you, because I'm also competent in law, so I can understand their teaching, and I can be like, okay, that makes sense, or no, that doesn't make sense, because I'm well versed with enough background knowledge that I can understand what I'm reading. Even if it's novel in its particular application, because just like any judge, right? I don't necessarily know everything, but I know enough background stuff to know whether you're teaching me makes any sense. So teach me, counselor, teach me things. It'll be exciting for us all to learn. Yeah. And Ludi says that changed when they changed statutes following BLM, as I just said, right? So my knowledge might be 5 years out of date. That was my entire background. Teach me. Teach me. Let's learn. All right. Carano began her professional career as a successful mixed martial arts fighter before she was given the opportunity to try her hand at movies. Indeed, Carano is the first ever female star in the mixed martial arts cage, fighting to successfully transition to a career in movies, breaking down a substantial barrier for women in sports. Okay. Carano received roles in Hollywood and independent film productions such as Haywire, for which she was nominated for a Critics' Choice Award for Best Actress, Fast and Furious 6, Heist, Deadpool, Almost Human, Extraction, Daughter of the Wolf, and Madison Method. On May the 13th of 2028, Gina Carano was the fastest rising search on Google and the third most searched person on Yahoo, while being ranked number 5 on Yahoo's top 10 influential women of 2008 list. Okay, fine. That sounds fine to me. All right, so we can skip. We're very successful. We're employed by a whole bunch of people. We are recognized, blah, blah, blah. We had some pay disputes, blah, blah, blah. We're successful, blah, 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 blah. Okay, great. We had a career. We've done things in the past. Moving on. All right, all this came to an end on February 10th, 2021, when defendants announced through media that Carano had been terminated from her role as Cara Dune and would not be hired for any other project with defendants, all because she expressed her political opinions on social media. Did they actually say that? That'd be helpful. I'm betting they didn't. In announcing the termination, Lucasfilm made the following public statement. Gina Carano is not currently employed by Lucasfilm, and there are no plans for her to be employed in the future. Nevertheless, her social media posts denigrating people based on their culture and religious identities are abhorrent and inaccessible. Okay, so Lucasfilm said some things that might imply potential motive to terminate, potentially. All right. Defendant statements characterizing Carano's social media posts as denigrating people based on cultural and religious identities was false. Well, it's an opinion, but okay. It was also made with knowledge of falsity with the purpose of harming Carano and to distract from defendant's illegal termination and treatment of Carano. You're saying that they said something false to distract, but this is the basis for which you're suing, right? Because they were firing me on that basis, and then you're also saying that's not the basis they fired me. I'm slightly confused. Defamation per se? I'm not even sure it's defamation per se, because I think it's an opinion. Her social media posts denigrating people based on their culture and religious identities are abhorrent and unacceptable. Yeah, that sounds like an opinion. I'm not even sure that's actionable in defamation, but, you know, someone else might disagree with me, but, you know, fair. Defendants targeted, harassed, publicly humiliated, defamed, and went to great lengths to destroy Carano's career, all because she made political statements that didn't align with what she believed was acceptable. Then Disney's then CEO has been quoted as saying Carano was fired because she didn't align with the company values, which is the most generic statement one could possibly make ever. In doing so, the CEO said these company values are values that are universal. Values of respect, values of decency, values of integrity, and values of inclusion. I'm not sure what you can get from that, to be honest. You think denigrating tries to present it as a fact? Yeah. Tough sell. The CEO's statements that Carano does not stand for values of respect, decency, integrity, and inclusion is false. His statement was also made knowing it was false with the intent to harm her. But it also shows Carano was fired not for her performance, but because her political opinions do not align with those of the Disney management. Well, at least her views on certain values, which may or may not be characterized as political, which are going to turn on state-specific law. This is all state-specific law driven. Defendants also discriminate against Carano by treating her differently from her male co-stars who also made public political statements. Maybe those statements more aligned with Disney. Her male co-stars were not disciplined, let alone terminated in a way to destroy their careers, even though some would find their statements abhorrent. Yeah, that some would, but whether Disney did or not. Yeah, that's more the key. Defendants harassed Carano for her political statements, subjected her to vilification, allow her other employees to harass her because of political views. Because of political views? Yet defendant did nothing when her male co-stars made statements that people would find equally, if not more, objectionable. Well, Disney is entitled, at the risk of pointing out the obvious, Disney and people at general are entitled to find abhorrent what they want to find abhorrent. And if someone makes a statement, they're allowed to find that abhorrent or not, depending on the context in which the person makes a statement. It's sort of up to them. You're not required to find any particular statement abhorrent or not. Or even any kind of imagery or not. Someone invoking the exact same concept might be found to be by you to be both abhorrent and not, depending on the overall context of the thing. Comoran says, I wonder how it works considering her statements were vague, but were interpreted inherently about Republicans. We'll see if that's what's going on. Hello on Twitch, by the way. Glad to have you here. Defendants retaliated against Carano when she objected to the harassment and efforts to force her to adopt positions against her conscience. In addition to terminating her, defendants refused to hire her for roles already promised. Okay, so there you go. That's something. Including but not limited Section 3 of The Mandalorian, the new series Rangers of the New Republic, and planned future Star Wars full-length films, which had recently been announced, all because of political beliefs and a disparate treatment from her male coworkers. Newspin says, I don't see how her post is denigrating. She doesn't give an opinion about any particular class or person or anything. It's comparing how people used to treat people and how they're treated today. Again, it's in the eye of the beholder. It's an opinion, right? What does it mean to be denigrating? What does that mean? It's in the eye of the beholder. You don't interpret that way, someone else might. It's an opinion, not a statement of fact, right? So that's why I say I don't think it's defamation, because it seems like more of a statement of opinion to my ear. Well, that's just me. Ron says you could paint it as retaliation to prevent her from future employment and tainting other opportunities. That would be tortious interference with prospective economic advantage, which is a hard sell unless you have specific, you can point to specific interferences with specific things. It's a very hard claim to make out in general. You believe integrity can be objectively assessed? Only with respect to what you're measuring the integrity against. So I suppose for any one person, you might be able to measure what is or is not integrity, but different people have different measuring sticks for what they figure is integral. So I'm not sure you can necessarily view that objectively either, but that's me. Moving on, defendant's actions were calculated, malicious, and knowing in violation of California law that protects employees such as Carano from discrimination because of the employee's political views and sex. All right. So now we're going to try to make the case that that's what happened. Christy says, I don't think she's suing for defamation. She's just mentioning at the moment. Okay, well, we'll see what her causes of action are. We haven't gone that far. It's all about discovery, perhaps, but I have to assess the case based on the prima facie case. Can we get to discovery? So let's find out if we can or not. You know, we have to make a claim to get to discovery. Let's find out if we can get there. Defamation is not a cause of action. Well, I don't know that. I haven't read that far ahead. Would you guys like me to read the thing so that I can assess for myself, please? Let's do that. Let's let Uncivil please read the thing and assess as he reads. That'd be great. Thank you. X, formerly known as Twitter, is a social networking platform. Carano has had an X or Twitter account since 2009. X allows its users to post content and see content posted by other users. X also allows its users, oh my sensitive day. I'm not sensitive, I just want to do my job. X allows its users and be followed by other users who post on X. Carano uses X to associate with and communicate with other X users, especially her followers and those she's following. X thus provides a vehicle for exercise of several constitutionally protected freedoms, including freedom of thought, freedom of belief, freedom of speech, and freedom of association. Well, that's X's prerogative to believe that or not. Carano uses X to express her views, opinions, and belief. Carano appreciates that X has never attempted to censor her speech, including the posts for which defendant subjected Carano to defamation, discrimination treatment. Carano knows she's responsible for the content of her posts on X. Well, X is entitled to its viewpoint, too. And GFN Wiz says, I think it was elementary school when I learned facts versus opinion. My wife is a middle school teacher, and it's sad the number of students who misidentify opinions as fact. Yeah, preach, right? So that sounds more like an opinion to me, not a fact. Because a fact by its nature, at the risk of pointing out the obvious, a fact by its nature is capable of being proven to be true or false. That's a fact. It was raining on the 11th. That is a fact. We can prove whether it was raining or not. Let's go roll that beautiful weather report footage, right? Is it denigrating? Is that a thing? How would you prove it if it's not? How would you prove it's denigration? How would you prove that? You can't prove it. Therefore, it's an opinion. There's nothing objectively to measure it by. It's an opinion. Yeah, so that's the thing. Commands aren't working today. Well, we're going to press on. I'm not going to deal with it right now. Carano uses X to express her... Okay, we read that part. Similar, Instagram is a social media platform. Plaintiff has had an Instagram account since 2012. While the incivility directed towards her started much earlier, over summer of 2020, Carano was constantly harassed and bullied on social media to support various causes, adopt various ideologies, and hold herself out in certain ways. I don't know if you say harassed or bullied. People just want people to reflect various viewpoints, and they want to have you parrot their words. I don't know if that's harassing or bullying, but, okay. When she declined, Carano was called all sorts of names, including that she was racist for not publicly adopting the Black Lives Matter moniker, and a transphobic bitch for not including pronouns in her profile biography selection. Yes, people on the internet say stupid things. Social media users demand that Carano publicly support Black Lives Matter movement, including adopting their slogans as noted in the following examples. Who cares what various social media people said? Who cares? Skip, 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 skip. While defendants did nothing to support Carano, which they're not necessarily required to do, fortunately, one of her castmates did have courage to stand up for her. Okay. Skip, skip, skip. Other users express support. No one cares. The online abuse worsened when she encouraged standing up to bullies by sharing an article with a famed historical photo of someone standing up to fascism. Gina Carano writing, heartbreaking and powerful story of a man who changed his ways for the woman he loved. Love changed the world one person at a time. Okay. It seems Disney Lucasfilm cares. Don't know that because we haven't had evidence of that yet. She's talking about... I'm just going to stop responding to comments. I can't get anything done. Carano was also attacked for questioning the strict lockdowns on business and churches, but non-protest is noted in the following post. Defendants made it known that they did not agree with or approve of Carano's political views. No one cares. No one cares. No one cares. Skip, skip, skip. Skip, skip, skip. This is her fighting with social media. I don't care. Blah, blah, blah. All right. Defendants engaged in harassment of their own. Okay, finally, we're going to get to something the defendants might have done. However, like her online abusers, defendants were not satisfied. They subjected Carano to long phone calls demanding explanation and criticizing her for not embracing what some see as mandatory solidarity with the vocal element of the transgender activist community. Okay, I mean, I would note that she's just saying this in very vague ways. What did they say? She's just saying things. I don't like it. Even where she expressed defense demands were excessive and asked for some time away, defense refused, demanding she continue with her re-education. What did they say? What meetings? What did they say? Why aren't you quoting them? I don't know. You're just saying things and I don't like it. I would like some facts, please. Please give me facts, not conclusions. I skipped an important post from her. Does the important post relate to Disney or Lucasfilm or any of the other defendants? If not, I don't fucking care. Because we're suing Disney, Lucasfilm, and the other defendants. So unless one of her posts has commentary from one of the defendants, I don't give a shit. I don't care. It doesn't matter. Defendant even required Carano to meet with a representative GLAAD, a nationwide organization that promotes LGBTQ. Something she willingly did. Well, if she willingly did it, then she can't complain about it, now can she? Carano had a very positive discussion with the two representatives, even reviewing documentaries that they asked her to watch. Upon representative belief, the representative GLAAD with whom she spoke provided positive feedback. Well, if she did it voluntarily, which she says she did, she willingly did it, so it doesn't matter, so I don't care. Even so, defendants continued to demand a public apology. What did they say? What did they say? Defendants went so far as to convince Carano publicly to... What did they say? How did they try to force it? What did they say? Please provide me some facts. As she refused to issue the statements, what statements? And defendants rejected proposed alternative statements. What alternative statements? Defendants increased their harassment. By doing what? As a sign of good faith, Carano went to donate to a GoFundMe page allegedly in support of the transgender community. When she opened the link, she read the fund was supposedly created by a Lucasfilm creative and was directed to target Carano, defaming her by accusing her of being bigoted, which is probably not actionable anyway. I think Florida recently was trying to pass laws to make these actionable, but generally speaking, not actionable. Carano brought this to Lucasfilm's attention and denied the GoFundMe account was established. Shortly after the account was changed to call Carano ignorant, and the identity of the organizer was changed to no longer identify Lucasfilm. Well, okay, fine. To Carano's knowledge, no employee was disciplined for their public harassment. Okay. Defendant nevertheless communicated to Carano's publicist that they're going to require Carano to participate in a Zoom call with Lucasfilm President Kathleen Kennedy and 45 employees who identify as part of LGBTQ. Going so far as to say her willingness to endure such harassment was a litmus test. You know what would be really great? Some statements from either Carano or her publicist about exactly who said what, Who said things? What did they say? Why aren't they in the lawsuit? They might be in an affidavit, but why aren't they here? Why not mention them here? What did they say? Hey, Carano's publicist, what did they say? What did they require? What was the... Okay. Give me some facts. I don't like this. The publicist was encouraged to explain the group was a friendly group that want Gina to succeed, even though several had contributed to the anti-fund account, including filmmaker Leslie Heelan, who's scheduled to promote a production. How do you know they contributed to the account? Maybe we have some facts we're going to bring at some point. That'd be nice. You could include a fact here. You could include a please see affidavit at line whatever notation would be good right about now. How about a footnote? How about a footnote says, oh, as said in the declaration blank, or said in the affidavit blank? How about that? That'd be great. The purpose was clear. Carano had to grow and learn. Are those quotes from where? Defendant wanted to know where her mindset was currently with regard to controversy. Is that a quote from where? No citations, no footnotes. I'm mad. Until then, they were not going to allow her to speak on media or include any of her promotions. How do you know that? What did they say? What did they say that said that they were not going to allow you to speak? What did they say? Was there an email? Was there a phone call? What did they say? Give me a fact. Give me a fact. All right, let me just explain this from baseline principles, okay? I have to, okay, in a motion to dismiss, I would have to accept any facts she offers me as true, okay? What I don't have to accept are any conclusions as true, okay? I have to accept the facts, not the conclusions. So far, all she's given me are a bunch of conclusions. I don't have any facts from which I could draw those conclusions. So far her motion, so far the motion to dismiss against her is looking really, really promising, because I'm like, well, she's going to say you have to interpret all the facts in my favor, and I, as hypothetical court, so far I'm like, what facts? You haven't given me any facts. Yeah. Carano declined to be subject to a Zooming with 45 other people, but did take 5 to 6 to dinner so they could face-to-face. Defendants refused the offer. Given defendants' ongoing harassment, Carano let defendants know that perhaps she needed legal counsel to help. Therefore, defendants changed course and decided to require her to take media training. Accordingly, defense harassment Carano was in full swing. Carano was also criticized for a post following the November election. On November 5th, Carano made the following post that expressed the sentiment. She said some shit. The social media backlash from those not share the perspective with SWIP. For example, one random asshole said some other things. Another random asshole said some other things. Still another asshole said some other things, and some other asshole said another thing. At no point did defendants defend Carano, but rather they continue to express dismay. By saying what? What did the defendant say? Here's a thing from a social media poster. Is that the defendant? No. Here's a thing from a social media poster. Is that the defendant? No. Here's a thing from a social media. It's like, what did the defendant say? What did the defendant do? The defendant didn't defend you. Okay. That's a thing they didn't do. But then you say they continue to express dismay. How did they express dismay? When did they express dismay? In what medium did they express dismay? What did they say? What did they do? Please give me a fact. Any fact would be helpful. Give me a fact. The fan reaction was a huge success. I don't really care either way, incidentally, because I suppose that might, yeah, I don't care. Defendant strike again. We're on page 31 of 59. It's not going great, guys. We're halfway through this complaint, and so far we're just saying shit. I'm not a happy camper. Yeah. What did they say during the phone call? I'll even take like vague recollections, right? It doesn't have to be word for word perfect, right? I mean, that'd be nice, but Disney said during the phone call these things. What things did they say? What did they say? Did they send you an email? That'd be great. What did they say during the phone call? Can you remember anything they said? Can your agent or your publicist, or like literally anyone, can they remember anything they said? Were there any emails sent to you? Would you like to tell me any of those things? What did they say? What did they do? What did the defendants do? All right. Defendants continue to harbor animosity. January 3rd, Carano was inadvertently sent an email by Lynn Hale of Lucasfilm. Hey, here's something. Here's a fact. That's nice. Explained defendants were consumed with some on social media calling for Disney to fire Carano. Okay. I mean, all right. So Disney has a lot of people complaining, and Disney has taken note. Which, you know, I mean, yeah, I mean, I would imagine. Sure. So this is garnered some of Disney's attention. Okay. They monitor hashtag meaning a string of related posts called Fire Carano. Okay. So Disney is monitoring. There's a deep concept. Wow. Thank you for explaining that to me. I would have never known that had you not explained that to me. So what you're telling me is that Disney is watching social media to see what people's reactions are to its work, to its employees, to its parks, to its movies, to its actors, to the things. What you're trying to convince me of at this point is that Disney, as an enterprise, spends part of its time monitoring social media, wondering what people are thinking about Disney, its movies, its actors, its employees, its parks, and so forth and so on. Wow, what an amazing concept. My mind is blown. Wow, that never would have occurred to me. And what you're telling me is that one of the things that Disney is currently occupying its time with is some of the critiques that have been given to Gina relating to her posts, as it may or may not relate to issues that concern Disney, and negative media backlash or negative social media backlash. They are concerned that one of their actors is getting negative attention, and they are concerned that that might potentially implicate Disney and or its business interests. Wow. Amazing. Deep. I'm glad you shared that with me. It never would have occurred to me had you not brought that up. Wow. That's deep. That's great. All right. The email was the most recent in a string of emails that began with the Disney CEO statement on January 6th. There was significant backlash to the statement, including harsh criticism of Disney for doing business with China, given the country's extensive human rights violations and internment camps. Well, yeah, Disney gets criticism for that too. I'm sure they've taken notes. Yeah, very quickly, the focus on the emails turned to Carano, as some on social media chose to insert calls to fire Carano in response to the statements. Okay. Rather than focus on the criticism of Disney's business dealings in China, Disney instead said it was going to report on Carano, which Hale recommended start by saying she didn't do anything to support the riots of DC. Of course, Carano had nothing to do with January 6th. Okay, so yeah, so here's the thing. All right, so Disney is an entity, and they're going to look at all the criticism and praise coming their way as they try to figure out their various courses of action, because that seems like something a reasonable corporation would do. I'm sure Disney has many employees whose entire mission it is in life to look at social media and try to figure out what is being said about them in every possible context, so that they can, bring that into the big hopper that is the Disney enterprise and figure out how to respond to it all as they try to figure out how to make everyone happy at the same time, which is always a rough go. Trying to please all the people all the time, that's a rough go. But they're gonna give it a shot. All right. Some of the things that Disney has been criticized for has to do with its business relationships in China. Disney obviously has tried to mitigate that to some degree. But Disney's response on how to respond to it is sort of up to them in the first instance, right? So one of the things that's like, hey, we're not happy that you do business with China. We don't think that's cool. We'd prefer that you stop. You're doing business with a country that imprisons people and has concentration camps and all the rest of it. Now, Disney, for its part, is like, China is an unbelievably huge market, and there's a lot of money, and we like money. Corporation goes, yay, money. Film at 11, film at 11. Unbelievable. So, they've decided to try to respond to this by trying to find ways to deal with this in PR land, by trying to make themselves not look like, assholes or hypocrites or anything else. All right? That's how they've chosen to respond to that, because they like money. All right, great. So one of the things, then they get criticisms about other things, and they get criticisms about all number of other things. Many things. They get criticisms and praise about all the things. For example, the Snow White film, for example. They've been getting a great deal of criticism for the things that its actress said. As we're trying to show, as long as we want to be fair to Disney, right? And Disney's not just a monolith that just promotes woke endlessly for the endless sake of woke. Excuse me 1 second while I take a drink of water. As we try to perhaps demonstrate that Disney is not a company that just tries to promote woke at the expense of everything else, one of the points of criticism that Disney has gotten recently is in relation to its new adaptation relating to Snow White and the Seven Dwarfs. And it is my understanding that Disney has had to undergo refilming and significant re-editing at significant expense to try to fix this, to the degree it can be fixed, because its lead actress said some stupid. They said their lead actress said some stupid. And Disney, having spent quite a lot of money on this, would like to try to see if it can be fixed. So they're like, well, what are we going to do here? Because we have already filmed this thing, and so what are we going to do? But Disney has apparently decided to try to go about fixing this by significant refilming and re-editing at significant expense and delaying the release of the movie to try to fix it. So they're not only all about the woke all the time. They do like money. And they got a lot of criticism, and they're like, oh, this is too much, so let's fix it. All right. Now, with respect to Gina Carano, right, there's a lot of people criticizing her. And as they're contemplating whether or not Gina Carano will be involved in future projects, it might be similar to whether they're contemplating whether or not the star of the new Snow White film will be in future projects, because, well, maybe this is just a thing we don't want in our life. Maybe it's just a thing we don't want in our life. So, yeah, they respond to criticisms in different ways. So Disney, not particularly eager to focus on the China issue because there's no real great solution for them as long as they like money, says instead they're going to focus on the Carano situation, which is a situation they can deal with. Or at least it's one they want to choose to deal with. It was apparent to the CEO and the team that were looking at ways to deflect from the failed leadership as CEO, a pattern that include obsession with and ultimate termination of Carano, his subsequent failing in the Disney contract dispute with Scarlett Johansson, that wasn't great, and political missteps and criticisms of Florida parental rights in education law, all leading to termination in November 2022. Yeah, there were many missteps made by Disney and stuff, yeah. On January the 12th of 2021, Carano posted an interview she gave where she asked about the controversy surrounding her social media posts. An interview that clearly demonstrates she was not seeking to denigrate anyone, but chose to speak up because there was a large group of people that were being silenced, and the conversations were not happening, and because of her belief that discussion is good. She was not seeking a political platform, but believed that discussing issues made everyone better. Well, all right, so she runs into a potential problem in her own lawsuit right now because she says, by her own words, she's not seeking a political platform. So if she's not seeking a political platform, then Disney's discrimination against her is not political. Because, right, we have to accept everything she says as fact. And she's speaking about herself at this point and what her intent was. So she can speak to that because she would know. She was there. It's her, right? So she says, okay, I'm not seeking a political platform. Okay, so how can you turn around and sue for discrimination on the basis of politics if you weren't speaking politically? That's a bit of a problem for her. All right. She understands that simply speaking up makes her a punching bag. Okay. All this occurred while Lucasfilm was publicly supporting Christina Ariel and her declaration that all white people are racist. Well, that's Disney's prerogative. Indeed, Disney and defendants even publicly claimed that people should speak their minds based on conscience. Of course, when Carano did so, defendants targeted her because her conscience didn't align with their ideology. So here's something coming from Disney. There comes a time when one must take a position that is neither safe nor politic nor popular, but must be taken because conscience tells them it's right. Well, I'm not sure that's necessarily encouraging people to do it as opposed to them grandstanding, but whatever. When they cite California labor law, well, it makes sense. It very well may. We'll see when we get there. On February 10th of 2021, Carano made the following post in light of the trending fire Gina Carano to highlight the injustice of the mob seeking to destroy someone because of their political belief. And then she wrote this thing. Gina Carano writing, Jews were beaten in the streets, not by Nazi soldiers, but by their neighbors, even children. Because history is edited, most people today don't realize that to get to the point where Nazi soldiers could easily round up thousands of Jews, the government must make their own neighbors hate them for simply being Jews. How's that any different from hating someone because of their political views? There's a point in there somewhere. Carano made no mention of a political party or particular point of view and compared no one to the people of the Jewish people during the Holocaust. Well, she might have not done it explicitly, but people might have thought that she was referencing herself because, you know, that would be a reasonable thing to infer from it being posted on your page. Now, wouldn't it be? Rather, she noticed the danger that arises from one point of view of singled out harassment. This is the post I believe is objectively not denigrating. I don't see how you could possibly view that objectively. How could you possibly prove it is or is not denigrating, which I keep continuing to mispronounce? I'm sorry. How could you possibly show objectively that this is or is not denigrating? How could you possibly prove that? By what objective standard could you say that it is or is not denigrating? I don't think it's possible. Therefore, it's an opinion. It doesn't comment on any specific person, class, or anything. It states facts and asks a question. You understand that there's this whole thing about implied, right? That things don't necessarily have to be stated explicitly. When we talk about defamation, we talk about this in the context of defamation by implication, for example. That was the whole thing, for example, for Johnny Depp when it came to Amber Heard. Defamation by implication. It's not what you say, it's the implication of what you say. So on straight text, on explicit text, no, maybe not. But what is the implication? Beyond the words, what is she talking about? Who is she talking about? She's talking about herself by implication. At least a reasonable person could think that. So she's comparing herself, at least potentially, to the Jews that were oppressed by their neighbors. That seems to be the natural implication by this. So that would be what I would say. A reasonable person could conclude that. So therefore, it is denigrating because it is comparing her own trials to those of the Jews, and that's pretty dismissive in a lot of ways to compare yourself in that way. So that's what one person could conclude. Aren't we responsible for what we say, not how it's received, like the Colorado case? He says peace, they hear the opposite. Well, the issue is not, you are responsible for what you say, but what you say can also be containing the implication of what you say. So you're not responsible for what people receive, but you are responsible for your implication of your, well, okay, first of all, we have to talk about different contexts. All right. Okay. So first of all, we have to make sure what context we're talking about things. If we're talking about incitement is different than, for example, defamation is different than something else. It's not denigrating at all. I'm trying to explain it. But maybe that's just your opinion. Yeah, you don't find it denigrating a Holocaust survivor. Might. It's subjective. Yeah, exactly so. Right? So you're not responsible for what other people hear, but you are responsible for what you say. And you're responsible for, to different degrees, depending on the context in which we're talking about it, you're responsible for the implications of your statement. Right? That's the theory that, for example, Nate the lawyer is suing Christopher Boozy over at the moment in his revised lawsuit. He's not suing at the moment for defamation on its face. He's suing for defamation by implication. He's suing for things not said but implied, because the idea is that Christopher Boozy was intending to imply them, and he has evidence to support that proposition, because Boozy for himself explicitly said, read between the lines, which is a statement to look for the implication. So you're not responsible for what other people hear, but you're responsible for what you say, including the implication. And so that's the difference. I don't know if that's helpful. And of course, the degree to which you're responsible for that implication is going to depending on what kind of thing we're talking about, especially from a legal framework. Are we talking about defamation? Are we talking about incitement? Are we talking about whatever? But yes, the implication is something that you could be held responsible for. And one implication that she's comparing herself to the Jewish people being oppressed during the Holocaust, and a Holocaust survivor might very well find that very denigrating. As I continue to try to learn to pronounce the word. Nevertheless, the apoplectic response, which is a word I like, apoplectic, which means extremely angry, which means insanely angry. It's a word I like, even though I can't pronounce it properly. Apoplectic, that's the right pronunciation. Apoplectic response. Yeah. Viscerally angry, insanely angry, apoplectic. It's a good word. The apoplectic response from someone on social media has been well documented and shows a gross overreaction and intentional smear campaign. By whom? Indeed, one analysis of social media events on February 10th, 2021 concludes, Carano's contested post can be fairly critiqued as heavy-handed. Still, evidence has not come forth that Carano in any way emitted an iota of hate or vitriol that was projected onto her by the prosecution mob. Indeed, the Auschwitz Museum even notes that the persecution of Jewish people began long before the concentration camps, which is true, a concept defendants refused to acknowledge even as they twisted and misrepresented the post. The Auschwitz Memorial said on November the 26th of 2018, and her post was 5 years later, so I don't think the Auschwitz people were talking about her. So 5 years earlier, or 3 years earlier rather, because it's 2018, the Auschwitz Memorial wrote, when they look at Auschwitz, we see the end of the process. It's important to remember the Holocaust actually did not start from the gas chambers. This hatred gradually developed from war, stereotype, and prejudice through legal exclusion, dehumanization, escalating violence. So yeah, the Auschwitz Memorial wrote that 3 years before all this happened, so probably not writing with that in mind. Even Carano's male star, the late Carl Weathers, posted the exact same message, but no action was taken against him, nor was Weathers accused. Carl Weathers said, "Who gets to decide what is appropriate for me or my child to read? The Nazis knew how to control and eradicate interesting playbook to emulate. What's next? Who's next?" That's not the same thing. And then someone else said, yeah. Someone else posted, it didn't start with the gas chambers, started with one party controlling the media, one party controlling the message, one party deciding what is truth, one party censoring speech and silencing oppression, one party dividing citizens into us and them and calling on them to support and harass them. It started when good people turned a blind eye and allowed it happen, but she's not necessarily responding with respect to herself or anyone else. The context is very, very different. Yeah. Defendant's disparate treatment of Weathers, which I don't think is disparate, further demonstrates the discrimination on the basis of sex and our political beliefs. Indeed, when she made the same generic statement, which I disagree, it's the same because the context is different. The context is different. She's making the post in the different context. It's understood differently. Weathers' comment was interpreted to attack Republicans, so he's given a pass by defendants. Maybe. I mean, that's speaking a lot to how defendants did or did not interpret that comment, to be honest, but okay. It's just a statement unto itself, right? When he wrote that, right, when he wrote it, because we are not provided any additional context. We are not provided any additional context, so we cannot assume any additional context. He's just writing a thing. All right, he's just writing a statement about it, so since we can't understand any context, we don't assume that he's talking about himself or referencing himself or his own plight or his own situation. He's just making a statement generically, and the other person making a statement generically. Whereas Carano's statement is made by her own admission, incidentally, by her own admission in this pleading. She's saying this is the fact. She's saying that the statement she made was in the context of her ongoing dispute with Disney and Lucasfilms. So her comment would be understood properly by that context, and therefore would be reasonable to assume she's talking about herself, which, you know, anytime you compare yourself to the Jewish oppressed, killed people, that's a hell of a comparison, right? People were mean to me on Twitter, and comparing yourself to the Jewish people of, you know, circa 1939 is one hell of a comparison, you know? Well, even actually earlier than 1939, because you're even talking about before World War II, so you're talking more like circa mid 1930s, to be honest. In fact, Carano constantly called for respect and decency when speaking with people, and for respect and decency to be shown, as she did when discussing important public issues. She's always held herself out as a person of integrity, and those she's worked with can attest to this. She always treated everyone she meets with kindness and compassion. Nothing can be more inclusive. It's a little self-serving. Defense not even have the courtesy to inform Carano of her termination. That is a little bit unprofessional. I agree with that. Ironically, Carano first learned of termination by reading on social media. That is a little bit unprofessional. As a result of the statement, Carano was inundated with stalkers immediately surrounding her home. It became so bad she began to fear for her safety. Yeah. In addition to being terminated from her role as the Mandalorian, defense canceled products of Rangers of New Republic, refusing to hire her, even though she'd been told the role was hers, which is their prerogative. If they don't want to work with, if they're not required to work with her, they're only forbidden from breaking the law, and they don't necessarily have to hire her or keep hiring her. Furthermore, prior to her termination, Carano had been told by Jon Favreau that she was to be part of the new Star Wars movie based on various Star Wars Disney series to be released in theaters in the near future, a group of movies which include the recently announced movie based on The Mandalorian. All right, and then there's a post-termination smear campaign. Carano filmed an episode of Running Wild with Bear Grylls. That's cool. Disney surreptitiously removed the episode that showcased Carano from the show's scheduled lineup, which, you know, is their prerogative. They don't have to necessarily broadcast anything they own. So that if they don't want to broadcast it, they don't have to broadcast it. That's their prerogative. They eventually did show it, and but they did remove all mention from her name or likeness of any promotional materials, which is also their prerogative. Based on defendant's termination and public statements, United Artists dropped there as a client. Neither provide an explanation. Discovery may reveal this occurred at the express or implied direction. If you can get to discovery, I have my doubts. The numerous opportunities Carano had because of her role, inviting invitations read for new movies, and even opportunities to promote were easily stopped. They made a very generic statement online. This is giving me flashbacks to what was it, Vic Mañana with his dispute with people saying things online. They're very, very generic statements and not enough to find actionable. It's yeah, I'm not super hopeful. We're on page 39 and 59, and it's not really working. Numerous opportunities had because of her role, including invocation read for new movies, attend high-profile events. Opportunities to promote her work immediately stopped. Even on October 2021, one of the co-stars was asked in Mandalorian, who is your favorite coworker? To which responds, my goodness, okay, you're asking for me one? Gina Carano. Okay, that's what one coworker had to say. That's nice. Another coworker said some nice things. Another coworker said some nice things. Forbes found it to be unjustified. Well, people might not agree with Disney, but the question is whether Disney can make the decision or not. So 72% of people disagreed with it. You know, so apparently 72% of people disapproved of the termination when they saw the actual post, because the post know the danger of targeting people for beliefs. So 72% of people thought the firing was unwarranted. Okay. Well, the question is not whether people in general think this or not. The question is whether Disney or not is allowed to think it. Is Disney allowed to have a different opinion or not? I mean, you know, yeah. You're still confused with what happened with Vic Mignogna? We're definitely not discussing that now. He got hosed. Well, no, his attorneys fucked up. His attorneys fucked up primarily, and he has to pay them $500,000. So that's what happened. So yeah, but we don't have to discuss that right now. Can you ask how it's different than Johnny essentially firing Johnny Depp? There is no difference so far. She has not brought about facts, and the one or two facts she has mentioned are so thin. It's like, no, I'm going to dismiss this with leave to represent, but uncivil judge is looking to dismiss. You haven't shown any facts. You vaguely alluded to conversations that happened without any specificity at all, even like a little bit. You know, it's not that you have to plead with specificity, but you do have to present enough facts to make, you know, the basic prima facie case, and you don't have it. You know, you don't have to necessarily go item by item and item with great specificity and spell out every single thing individually, but you have to provide me as hypothetical judge with enough facts that would make the prima facie case, and you haven't come even remotely close so far. Yeah. It wasn't really Ty, by the way, who dropped the ball. It was one of his other co-lawyers who dropped the ball. Although Ty, of course, being chief counsel, did have to eat it because, you know, he's the man at the top of the letterhead. But, you know, yeah, they fucked it up. All right, so social media posts, some co-stars said some nice things. All right, or not. All right, so here we're going to try to point out how other people have said things for which Disney didn't react. And okay, I'm not necessarily sure how that. If we're going to try to show disparate treatment, that's going to be tough. Let's see if we can make it work. If they dismiss, you get the chance to revise and add in the facts. Yeah, that's what I said. I dismiss with leave to represent. I would dismiss with leave to represent. She can give it another go. Would be my inclination. Yeah. Do we have any exhibits in the following? I don't think so. Not that I see, and we certainly haven't heard. We haven't seen any referenced. We haven't seen any reference. We haven't seen any footnotes. We haven't seen any citations to anything. We haven't seen please see declaration of whatever. Please see affidavit of whatever. We haven't seen any of that stuff. So apparently not. No. And incidentally, you do want it in the complaint. You can't just be like, you can't just be like, see affidavit A. You know, you have to integrate that stuff into the complaint. You can't be just like, here's a whole bunch of conclusory bullshit. Please see exhibit A, where we're going to, you got to bring in the facts into the complaint. You don't have to bring in everything. You know, you don't have to bring in all the things, but you have to bring in enough into the context of the complaint so I can be like, okay, I can track within the complaint itself. So no, this is not working. This is not working. You know, this so far, in my opinion, this is a sloppy file. That's my opinion. This is a sloppy file. Carano respects the right of her co-stars to express their views, even if they differ from her own. She remains personally fond of them. However, defendant's treatment of Carano stands in stark contrast to defendant's embrace of her male co-stars and other male employees. So the following examples are provided to demonstrate discriminatory treatment. They say embrace. Defendants embrace. Okay, let's see if they embrace them. One of Carano's co-stars was Pedro Pascal, a male actor who played a role of the Mandalorian. Pascal was active on social media, often expressing his views on Black Lives Matter, LGBT, protests for abortion in the 2020 election. For example, in 2015, Pascal made the following post, drawing a clear distinction between himself and conservatives. Pedro Pascal saying conservatives use gossip columns and headlines to manipulate city politics in the 40s. And it worked. Let's be better than them. That's a pretty banal statement, but okay. On August of 16th, 2017, Pascal made the following post comparing Donald Trump to Hitler. Probably not a view which created a lot of problems for Disney, I would imagine. You know, especially as we're looking, if we're looking at what is the reason, right? Because this all comes down to what is the reason we're doing it, right? Are we discriminating on the basis of sex? Are we discriminating on the basis of political idea or affiliation? Are we discriminating on the basis of public backlash? Are we discriminating on the basis of public perception or our public profits or money? What are we discriminating on the basis of? Right? And so, okay, so Pascal made this following post about Trump and Hitler, which probably didn't, get a lot of people's rankles up. And not that you've noted, by the way, you haven't noticed where Pascal got a lot of comments from the public where this is like bad and horrible and all the rest of it, right? So did you note that Pascal's comments got a lot of stuff and there was a problem and all the rest of it? No. 2017 was not the only time Pascal compared Trump and those who voted for him for Nazis. Pascal in 2018, Pascal compared the United States responding to the country and to those entering the country illegally to concentration camps by saying Germany 1944, America 2018. Not for nothing, by the way, but of course, when it comes to immigration, they can leave those prisons anytime. They can leave those prisons anytime. I'm just saying, they can. Now, all they have to do is go back home because they're illegal immigrants. They can leave. And with the concentration camps with the Jews, they couldn't have the ability to leave. They weren't allowed to leave. The people being held in detainment for immigration, they can leave those jails anytime, man. No problem. And again, on November 7th, 2020, Pascal made the following post, only deleted shortly thereafter. So Pascal apparently posted losers in 1865, Confederate flag, losers in 1945, the Nazi flag, losers in 2020, the Make America Great Again hat. Well, I mean, that's a perspective of some people, not a perspective I agree with, but it's an opinion. Okay. California passed a law to protect BLM opinions. We haven't gone that far. We haven't gone that far into their legal causes of action, but I'm not really sold on their presentation. We'll see if it gets any better when we ultimately get to the causes of action, although I have my doubts. You know, I have my doubts severely. Defendants didn't comment, let alone condemn. Well, you said earlier, that's not what you said earlier. In 135, you said defendants didn't comment on it, but you said earlier that, what was it? You said in 127, however, defendants' treatment of Carano stands in stark contrast to defendants' embrace. And then in 135, you say they didn't comment on it at all. Oh, that's kind of different now, isn't it? In 2020, Pascal posted 2 Disney-owned Muppets, Bert and Ernie, as activists wearing a transgender and LGBTQ flag, promoting Black Lives Matter and defund the police. Okay. Cool. All right. We'll see when we get to the causes of action. We haven't gone that far. Upon information belief, Pascal was not disciplined or required to view documentaries on any topics or speak to individuals, so they didn't embrace him so much as not doing anything. His employment was not terminated. Defendants made no statements, so they didn't embrace him so much as not do anything. Okay. Likewise, Star Wars star Mark Hamill posted a comparison of Americans support Donald Trump with Nazis by saying, "I do not see a thing," with a bunch of people like holding their hands up at a Trump rally for something. I'm not sure what the context is there. This, of course, is nothing new for Hamill, so whatever. Hamill's gone so far as to compare Trump to the Third Reich without a word of protest, which is not the same thing as embracing them. However, all right. Defendants didn't comment on stuff, and like Carano, when Hamill was accused of liking a transphobic tweet, his explanation was accepted by defense without question, so they didn't say anything. All right. No action was taken against Hamill. On the contrary, he's allowed an appearance in The Mandalorian. Defense even rehiring Gardner, the Galaxy director, after terminating him in social media posts for years earlier, saying is like, "I like when little boys touch me in my silly place." That's not great. And the best thing about being R-word is when you're done being R-word, it's like, wow, that feels great, not being R-worded. And the Expendables were so manly, I effed the shit out of the little pussy boy next to me. The boys are back in town. Well, rehiring that guy seems questionable. All right, so let's try our causes of action. California Labor Code 1101. Carano re-alleges and incorporates the following. California law provides that no employer shall make, adopt, or enforce any rule, regulation, or policy forbidding or preventing employees from engaging or participating in politics or becoming candidates for public office, controlling or directing or tending to control or direct the political activities or affiliations of employees. In violation of law, defendants terminate employment based on our posts, thereby unlawfully forbidding. You have no evidence to support that. You have no facts to support that. In violation of law, defendants terminate employment and refuse to hire for other promoted roles based on her posts. You have no facts to support that. Section 1102 says no employer shall coerce or influence or attempt to coerce or influence his employees through or by means of threat of discharge or loss of employment to adopt or follow or refrain from adopting or following any particular course of line of political action or political activity. In violation of law, defendants coerced, influenced, and attempted to coerce Carano because of her posts by means of threat of discharge or loss of employment to adopt or follow or refrain from adopting. You have no facts to support that. The termination of Carano's employment and refusal to hire her was motivated by disagreement. You have no facts to support that. Defendants attempt to curtail Carano's political activities outside the workplace also involves employer policy. You have no facts to support that. The termination of Carano and refusal to hire her served as an implicit warning. Speculative. and message to defense other employees that expression of views departing from liberal perspectives on Black Lives Matter, the coronavirus, transgender issue, and political polarization will not be tolerated. You have no facts to support that. Yeah. You have no, this is just a big nothing burger. Well, that's why I'm reading it, to see what it is, right? A lot of people have commented about this. I want to comment about it and offer my opinion. So that's what we're here to do. Sometimes we read things and we're like, you know what? This isn't working. This isn't working. That's sometimes an opinion. California Section 11105 provides nothing as chapter shall prevent the injured employee from recovering damages. The section provide them with a private right of action. I'm sure it does, but you don't have any facts. Defendant's actions damage Carmona not only loss of the role, but are promised role at already approved roles. Defendant's actions further damage Carano by causing others to stop doing business with her. That is incredibly speculative. That is incredibly speculative, and I don't think is really a cause of action in this way. Are you sure you don't want to try this as an intentional, as intentional interference with prospective economic advantage? Incidentally, you're not going to win that either, but that would be the right cause of action. Second claim, wrongful discharge or refusal to hire. Section 98.6 says a person shall not discharge employer or any manner discriminate, retaliate, or take adverse actions against an employee or applicant because the employee or applicant engaged in any conduct delimited as chatter, including conduct described in the relevant law, you know, because of political stuff. In violation of law, they refuse to hire, you don't have facts, or you don't have facts, you don't have facts. Sex discrimination, you don't have the facts to support that either. What else? Prayer for relief, no. All right, and demand for jury trial, no. All right. So, my assessment. My assessment. Here is the relevant law to conclude it. As we look at the issue of a potential motion to dismiss, a motion to dismiss is interpreted against the moving party. Disney is going to move to dismiss. We're going to interpret everything against them because that's how we roll. We will assume every single fact that Gina Carano has to offer is true because that's how we roll. We, however, do not have to accept any conclusions that she makes. That is for the court to decide, the conclusions that flow. And they, of course, the conclusions that flow would also be interpreted in the most favorable light to Gina. So basically, do we have the prima facie case? Accepting every fact that she offers as true. Do we have a prima facie case as to any of these things? In my opinion, the answer is no. We have a lot of conclusory statements and a lot of vague statements about, oh, Disney made this phone call. Disney did this. But we don't have any quotes. We don't have any words. We don't have a declaration from Gina or any of the other people, from her agent, from her publicist, from anyone else who might be in a position. We don't have any emails that might affirm this, any DMs that might affirm this. We don't have any statements that says, here's what they said on a phone call. Here's what they pressured me. We don't even really have anything in detail about like what specifically they said, just vague allusions to Disney pressured me at various times. When? In what way? What did they say? What was the threat? Real or implied? Or what did you interpret? There's not really things here. And to the extent there are things here, there's like one or two or maybe three things that you could interpret as maybe a positive statement about what Disney did. And it's far from enough to get to a prima facie case. So in my opinion, we don't make it into discovery. If we can't make it past a motion to dismiss, we don't make it to discovery. Because you can't go fishing. You can't go fishing. No bee fish. No bee fish. You can't go fishing. You have to have enough evidence, enough facts. Again, evidence is even the wrong word because you can just speak facts into existence as long as you have any basis. And you were there, right? You were there. So you heard things, you saw things, you were told things, people said things. You can just say them. You can just say them as long as you believe them to be true. But you can't go fishing. And right now, this complaint is a massive fishing exercise, in my opinion. We don't make it past the motion to dismiss, in my opinion. There's just nothing here. There's nothing here saying that Disney said this. This was when the call occurred, or Disney made these representations. Just vague, conclusory things. Disney threatened me. That's a conclusion. Disney threatened me. How did they threaten you? Disney threatened my job. That's a conclusion. How did they do that? What did they say? When did they say it? Anything. Right? It doesn't have to be a lot. It doesn't have to be a huge amount. Just enough stuff to get me past the prima facie case. And you don't have it. What you do have is, oh, and then with respect to other people like Pedro Pascal, Disney didn't do things. And you don't really even have that Disney did things in, by the way, except for their one tweet, right? And that was even from Lucasfilms. So even if you could somehow get past a motion to dismiss with respect to Lucasfilms, you can't get past a motion with respect to, okay, so we're suing 3 people, right? We're suing Walt Disney, Lucasfilm, and Huckleberry. Okay, first of all, how is Huckleberry related to any of this bullshit? Who is Huckleberry again, by the way? Huckleberry's incorporated. Huckleberry's a citizen. They're a wholly owned subsidiary of Walt Disney. So they are Walt Disney. Huckleberry's Walt Disney. Fine. So they're one of their subsidiaries that maybe produced The Mandalorian or something. It doesn't really matter. They're just a subsidiary. So it's Walt Disney, Lucasfilm, and Walt Disney. Fine. Great. So to the extent we have anything, we have one tweet from Lucasfilm that says, okay, we're not hiring her anymore and we don't really like her values. And that's about it. That is a thin thing to try to get from. I don't think we get past a motion to dismiss with Lucasfilm. If you're really lucky, maybe, but I doubt it. And you don't really have anything from Walt Disney or Huckleberry at all, except these vague allusions to conversations that might have occurred, that might have said something, that might have been threats, and they're just all vague conclusions. I'm like, this is, okay, yeah, dismiss for failure to state a claim. Dismiss for failure to state a claim, all 3, and maybe if you're really lucky, maybe somehow you get in limited discovery for Lucasfilm, and that's about it. But I think dismiss for all 3. So that's what I think. My understanding is my compatriots out there in the LawTube land are more optimistic about this lawsuit than me. But I read this and I'm like, this is all just speculative garbage. There's nothing in here. There's nothing I can sink my teeth into. Disney said, here's what they said. Here, you know, what Disney said what? We don't even have any names of anyone at Disney, right? We don't have, you know, we don't have so-and-so, you know, we don't have Bob Smith from, you know, Disney, whatever, called me and said, and Jim Jones from Disney emailed me and said, and Lucille Price, you know, called me and said, or Alfred Blue. You know, we don't have any of those things. It's just incredibly thin. It's a huge nothing burger. Yeah, we don't have any of those things. Nate doesn't see much here either, so Nate and I are in agreement then. Yeah, no, we don't see anything here. So my humble opinion is we're looking at a motion to dismiss and a grant of dismissal with leave to represent. Please come back with any facts at all that can make the prima facie case. And by the way, of course, with respect to each party. You have to make the prima facie case with respect to each party. So please come back and make the prima facie case as to each party, and let's try this again. That'd be great. So that's where we're sitting. So, yeah, I'll take your comments at this time. Now that I've given you the bad interpretation. So is there any comments before I end the stream and have another bowl of my chicken soup, which I'm enjoying very much? She's asking a federal judge for a federal jury, which would be to her advantage, incidentally, because she is asking for a jury which would be drawn from the entire Central District of California, which is to her advantage, as opposed to suing in a county somewhere. So she would get a nice jury. Was the light matching shirt? No, that was just accident. It just happened to be available. Especially, I would imagine, I mean, I wouldn't know for sure, but I would imagine that a judge, even a federal judge, sitting in California, I mean, federal judges tend to be, they don't dick around as much. Just basically, yeah, they don't dick around as much. So I think they'd be less inclined. They don't play as much. So yeah, I think a federal judge is going to be like, nah, I don't think so. The union she's part of. Well, since the union she's part of didn't make a single appearance in this complaint, I'm going to completely ignore that for the moment. To the extent that she's in a union and to the extent it would matter, it can only matter as it would benefit Disney. And the reason I know that is because she didn't mention it once in her entire complaint. So if her being in a union would have benefited her at all, presumably she would have mentioned it in her complaint. So since she didn't, either it's neutral or it benefits Disney and they're going to mention it as part of their response. So her being in a union can only hurt her in this respect, I would imagine. So yeah, I don't think that's going to be a help. Can she amend refile? I would allow her to amend refile. That's what I would do. I would dismiss it with leave to represent. I would dismiss it without prejudice. You only dismiss with prejudice if you can't fix it. And this can be fixed in principle, right? It's not like she can't fix it. All she has to do is present more stuff. Some of which is within her control, right? Things she knew, things she observed, she heard, her publicist, her agent, presumably these are things that are within her control. Emails, records, dates of phone calls, vague quotes, anything. Yeah, so I'd give her leave to represent. I wouldn't dismiss it with prejudice. She gets another try. She can get another try at this. I ignored your subscription. I'm sorry, Paris. I didn't want to ignore your subscription. I'm sorry. Thank you for becoming a civilian. This is the first shot across the bow. Disney's not going to settle. Why would they? They're going to crush you on the motion to dismiss and they're going to win. The odds of this ever making it to trial are, of course, somewhat thin. Most cases settle. If they ever do get to discovery, if they do make it past a motion to dismiss, then there's very high chances for settlement. Of course, Disney might try to settle for something now, but if I were Disney's lawyers, I'd be strongly disinclined to settle for something now. Why bother? If I were going to settle, it'd be for a fairly token amount. I'm Disney, though, so what's token to Disney is going to be a lot, but, I would not be incentive. As Disney's lawyer, I'd be like, no, we're not going to settle this. Screw this. Would Disney having record of actions be enough to get this dismissed? Yeah, maybe, but they don't have to right now. They can win just on her own complaint. They can win within her complaint. Thank you, Tony, for this. Yeah, I appreciate this. Yeah, I seriously doubt they'll settle. They're going to file a motion to dismiss, and I imagine they're going to win. Maybe Gina files an amended complaint in response to the motion to dismiss. Maybe she realizes her teeth are kicked in so hard, she files an amended complaint before they can get the dismissal. Or maybe this was just to yeah, Yeah, I would be very strongly disinclined to allow her to go to Discovery. You can't go fishing. You can't go fishing. I'm not going to allow you to go to Discovery, go fish. You have to provide me enough to get past the motion to dismiss. All right, I think we've covered this enough. It's getting a little repetitive and I want some more chicken soup. So I'm going to sign off for now. I hope you've enjoyed this stream. I hope you've learned something from it. The stream wasn't as popular as I hoped it would be. I thought it would be more popular, but then again, I am a couple days old on this one. So I am a couple days out of sync on this. So we'll see how that goes. But I hope otherwise you enjoyed it. I've been Uncivil Law, and until later, my friends, I hope all is well. Cheers, my friends, and goodbye.